Wrong bankruptcy chapter filed, and you lose everything avoidable. Drowning in debt does not mean your life is over. Florida bankruptcy law gives you powerful legal tools to wipe out debt, stop foreclosure, and rebuild your financial future. But filing the wrong chapter can cost you your home, your assets, and years of your life. Here is exactly what you need to know: why bankruptcy exists and what it actually does. Bankruptcy is a federal legal process under Title 11 of the U.S. Code, but Florida's exemption laws determine what property you can keep. It is designed as a legal reset for people overwhelmed by debt, not a moral failure. When you file, an automatic stay under 11 U.S.C. Section 362 immediately stops all collection actions, including calls, lawsuits, garnishments, and foreclosures. Creditors must cease enforcement or face court penalties. Most individuals in Florida file either Chapter 7 or Chapter 13 bankruptcy, which differ based on income, assets, and repayment ability. The right option depends on your financial situation and long-term goals. What is Chapter 7 bankruptcy in Florida? Chapter 7 bankruptcy is commonly called liquidation bankruptcy. It is the fastest and most straightforward form of personal bankruptcy available. In a Chapter 7 case, a court-appointed trustee reviews your assets and discharges, meaning legally eliminates most of your unsecured debts. Unsecured debts include credit card balances, medical bills, personal loans, utility arrears, and most other debts that are not backed by collateral. The entire Chapter 7 process in Florida typically takes between 3 and 6 months from the date of filing to the date of discharge. Once your discharge is entered by the bankruptcy court, those eliminated debts are gone permanently. Creditors are legally forbidden from ever attempting to collect them again. Chapter 7 does not mean you automatically lose all of your property. Florida has some of the most generous bankruptcy exemptions in the entire country, and those exemptions determine exactly what you keep. Florida's bankruptcy exemptions, what you keep in Chapter 7. Florida bankruptcy exemptions are primarily found in Chapter 222 of the Florida Statutes and Article X, Section 4 of the Florida Constitution. They determine what assets a bankruptcy trustee cannot take. Florida's homestead exemption is especially powerful, allowing an unlimited value primary residence within specific acreage limits. Under Florida Statute 222.25, residents receive a $1,000 personal property exemption, or up to $4,000 if the homestead is not claimed. Additional protections include life insurance and annuities, wage protections for heads of household, retirement accounts under federal law, and limited vehicle equity. These rules allow many filers to keep essential assets while eliminating unsecured debt. Who qualifies for Chapter 7, the means test? Not everyone can file Chapter 7. Congress created the means test under 11 U.S.C. Section 707(b) to ensure that Chapter 7 is only available to people who genuinely cannot afford to repay their debts. The means test compares your average monthly income over the 6 months before filing against the Florida median income for a household of your size. As of current figures, the Florida median income for a single-person household is approximately $54,000 annually. For a family of 4, it is approximately $83,000 annually. These figures are updated periodically by the United States Trustee Program. If your income is below the Florida median, you automatically pass the means test and qualify for Chapter 7. If your income is above the median, a more detailed calculation is performed examining your allowable expenses and disposable income. If you have too much disposable income after allowed expenses, you may be required to file Chapter 13 instead. What is Chapter 13 bankruptcy in Florida? Chapter 13 bankruptcy is called reorganization bankruptcy. Instead of eliminating debt immediately, Chapter 13 allows you to restructure your debt into a manageable 3 to 5 year repayment plan that you propose to the bankruptcy court. At the end of the repayment plan, remaining eligible unsecured debts are discharged. Chapter 13 is fundamentally different from Chapter 7 in both purpose and outcome. You are not liquidating assets. You are reorganizing your financial obligations under court supervision and protection. Chapter 13 requires regular monthly income because you must make plan payments throughout the entire repayment period. Under 11 U.S.C. Section 1322, Your Chapter 13 plan must pay certain priority debts in full, including back taxes owed to the IRS or Florida Department of Revenue, domestic support obligations such as alimony and child support, and administrative expenses of the bankruptcy case. Secured creditors such as mortgage lenders and car loan companies must receive at least the value of their collateral. Unsecured creditors receive whatever is left of your disposable income after all required payments are made. 5 situations where Chapter 13 beats Chapter 7. Saving your home from foreclosure. Chapter 13 is the most powerful tool available under federal law for stopping a foreclosure and catching up on missed mortgage payments. If you are behind on your mortgage, Chapter 13 allows you to spread those arrears over your 3 to 5 year repayment plan while continuing your regular monthly mortgage payments going forward. At the end of the plan, your mortgage is current and your home is saved. Chapter 7 does not provide this cure mechanism for mortgage arrears, protecting non-exempt assets if you own assets that exceed Florida's exemption limits. A second vehicle, investment property, significant savings, or business assets. Chapter 7 requires you to surrender those assets to the trustee or pay their equivalent value. Chapter 13 allows you to keep all of your assets as long as your plan pays unsecured creditors at least what they would have received in a Chapter 7 liquidation. Stripping a second mortgage in Chapter 13. If your home's current market value is less than the balance owed on your first mortgage, a second mortgage or home equity line of credit can be stripped off entirely under a process called lien stripping. The stripped second mortgage is treated as unsecured debt and eliminated at the end of the plan. This is not available in Chapter 7 and can save homeowners tens of thousands of dollars. Discharging non-dischargeable debt. Certain debts that cannot be discharged in Chapter 7, including some older income tax debts that meet specific requirements and property settlement obligations from divorce that are not classified as support, can sometimes be addressed more effectively through a Chapter 13 plan. Filing again after a prior bankruptcy. If you previously received a Chapter 7 discharge, you must wait 8 years from the filing date of your prior case before filing Chapter 7 again. However, you can file Chapter 13 just 4 years after a prior Chapter 7 discharge. For people who received a prior discharge and face new financial difficulties, Chapter 13 may be their only available option. Head-to-head comparison. 6 key factors. Timeline. Chapter 7 closes in 3 to 6 months. Chapter 13 lasts 3 to 5 years. Income requirement. Chapter 7 requires passing the means test. Chapter 13 requires regular income to fund the repayment plan. Asset protection. Chapter 7 relies entirely on Florida exemptions. Chapter 13 protects all assets regardless of exemption limits. Mortgage arrears. Chapter 7 cannot cure mortgage arrears. Chapter 13 is specifically designed to save homes from foreclosure. Credit impact. Both chapters appear on your credit report. Chapter 7 remains for 10 years. Chapter 13 remains for 7 years from the filing date. Cost. Chapter 7 attorney fees in Florida typically range from $1,000 to $2,000. Chapter 13 attorney fees typically range from $3,000 to $4,500 due to the complexity of plan preparation and ongoing court representation throughout the repayment period. What bankruptcy cannot do. Understanding the limits of bankruptcy is just as important as understanding its power. Bankruptcy cannot discharge student loan debt except in extremely rare hardship cases. Cannot discharge child support or alimony obligations. It cannot discharge most recent income tax debts. It cannot discharge debts arising from fraud, intentional misconduct, or drunk driving injuries. Cannot discharge criminal fines or restitution. And it cannot protect a cosigner on your debt from collection unless that cosigner also files their own bankruptcy petition. The most important step before filing. Before filing any bankruptcy petition in Florida, federal law requires completion of an approved credit counseling course within 180 days before filing under 11 U.S.C. Section 109H. Before receiving your discharge, you must also complete a debtor education course. Both courses are available online through approved providers and typically cost between $10 and $50 each. Failure to complete these requirements results in dismissal of your case. Conclusion. Chapter 7 gives you the fastest fresh start and works best when your income qualifies. Your assets are protected by Florida exemptions, and your primary goal is eliminating unsecured debt quickly. Chapter 13 gives you the power to save your home, protect non-exempt assets, and restructure debt over time when you have regular income and specific property you need to keep. Neither chapter is better in the abstract. The right chapter is the one that matches your specific financial situation, your income, your assets, and your goals. That determination requires a careful analysis that only a qualified bankruptcy attorney can provide.